The next witness is Philip Zelikow, who is the White Burkett Miller Professor of History at the University of Virginia, one of my alma maters. It's very good to have him here. He was counselor at the Department of State, a deputy to Secretary Condoleezza Rice from 2005 to 2007. From 1998 to 2005, Mr. Zelikow directed the University of Virginia's Miller Center of Public Affairs, as well as 3 bipartisan commissions, including the National Commission on Terrorist Attacks upon the United States, referred to colloquially as the 9/11 Commission, from 2003 to 2004. Previously, Mr. Zelikow served as a career Foreign Service officer at the State Department and on the White House National Security Council staff. He is currently a member of the board for the Global Development Program of the Bill and Melinda Gates Foundation. Mr. Zelikow received his baccalaureate degree from the University of Redlands, a law degree from the University of Houston, and his master's and PhD from the Fletcher School at Tufts University. Mr. Zelikow, welcome. We await your testimony.
Mr. Chairman, Senator Graham, thank you for giving me the opportunity to appear before you today. The committee has my CV. I won't detail my experience. I'll just say that I was working on counterterrorism for a number of years before 9/11. I have experience looking at this as both a scholar and as a policymaker. I was a member of the President's Foreign Intelligence Advisory Board from 2001 to 2003, so I do remember what it was like after 9/11 and what some of the issues were at the time. And I've had some responsibility in having to make tough decisions on these issues from the policy side. I've submitted to the committee a lengthy written statement that goes into a lot of detail, which I'm not going to recapitulate in detail. Basically, the statement touches on some reasons why I think we chose to get into a program of this kind. Just trying to step back and analyze it, because I think in many ways this was a large collective failure in which a lot of Americans from both parties thought they needed a program like this in order to protect the country. I think we can now judge that to have been a mistake, as Senator Graham said in his opening statement. Therefore, it's important, since this was a collective failure and it was a mistake, to learn from that mistake, comprehend why we made it. So I have a few things in the statement that go into that. Further, I then talk about my work on these issues as our suspicions grew about them in the 9/11 Commission. The 9/11 Commission included a recommendation that was designed to anticipate some of these concerns, a recommendation that the administration ignored, which was itself an ominous sign. And then my getting involved more directly with these issues when I joined the State Department at the beginning of 2005. During most of 2005, the main focus in our work to get this to change, and by our work I mean the work of Secretary Rice, legal advisor John Bellinger, and I, in a series of principals and deputies meetings that had been put in motion by President Bush because he clearly wanted his advisors to reevaluate all these issues. During 2005, we mainly focused hard on getting the administration to agree to the standard the 9/11 Commission had proposed, which is, please accept the CID standard. The CID standard is an acronym that stands for cruel, inhuman, and degrading. In other words, please accept that we're going to have all our intelligence programs covered by this basic provision of the law of armed conflict, which is codified in various ways, including in our domestic law, I believe, through the federal war crime statute. By the end of 2005, those efforts had been successful. The various battles that went on are detailed in my statement, including a couple of documents that reflect the positions that I adopted along with the Deputy Secretary of Defense and others that give you some illustration of the way we were making these arguments in June and July of 2005. By December of 2005, that battle had been won, both because of internal work but also because of the McCain Amendment. It was clear that CIA and the government were going to have to accept a CID compliance analysis. Thus, by early 2006, there was no way for the administration to avoid the need to reevaluate the CIA program against a CID standard. The work of the NSC deputies that I was involved in intensified. The OLC had guarded against the contingency of a substantive CID review in its May 30th, 2005 opinion. OLC had held that even if the standard did apply, the full CIA program, including waterboarding, complied with it. That is, the full CIA program, including waterboarding, did not violate proscriptions against cruel, inhuman, and degrading treatment. The OLC view also meant, in effect, that the McCain Amendment was a nullity. It would not prohibit the very program and procedures Senator McCain and his supporters thought they had targeted. So, with the battle to apply the standard having been won, my colleagues and I at the State Department then had to fight another battle over how to define the standard's meaning. That meant coming to grips with OLC's substantive analysis. OLC contended that these subjective terms like cruel or humane should be interpreted in light of the well-developed and analogous restrictions found in American constitutional law. Therefore, to challenge OLC's interpretation, it was necessary to challenge the Justice Department's interpretation of U.S. constitutional law. This was not easy, since OLC is the authoritative interpreter of such law for the executive branch of the government. Many years earlier, I had worked in this area of law. It seemed to me that the OLC interpretation of U.S. con law in this area was strained and indefensible in a whole variety of ways. My view was that I could not imagine any federal court in America agreeing that the entire CIA program could be conducted and it would not violate the American Constitution. While OLC's interpretations of other areas of law were well known to be controversial, I did not believe my colleagues had ever heard arguments challenging the way OLC had analyzed these constitutional protections. Further, the OLC position had implications way beyond the interpretation of international treaties. If the CIA program passed muster under an American constitutional compliance analysis, then, at least in principle, a program of this kind would pass American constitutional muster even if employed anywhere in the United States on American citizens. We'll reflect on that for a moment. So I distributed my memo analyzing these legal issues to other deputies at one of our meetings in February 2006. I then took off to the Middle East on other work. When I came back, I heard the memo was not considered appropriate for further discussion, and that copies of my memo should be collected and destroyed. That particular request, passed along informally, did not seem proper, and I ignored it. This particular memo has evidently been located in State's files and is being reviewed for declassification. The broader arguments over the future of the CIA program went on for months, even though the old program had effectively been discontinued. Internal debate continued into July of 2006 after the Hamdan decision, culminating in several decisions by President Bush. Accepting positions that Secretary Rice had urged again and again, the President set the goal of closing the Guantanamo facility, deciding to bring all the high-value detainees out of the black sites and move them toward trial, seek legislation from the Congress that would address these developments, and defend the need for some continuing CIA program, but one that would comply with relevant law. And President Bush announced those decisions on September 6, 2006. I left the government at the end of 2006 and returned to the University of Virginia. Secretary Rice and Mr. Bellinger remained deeply involved in these issues for the following 2 years, working for constructive change. But in sum, the U.S. government, over the past 7 years, adopted an unprecedented program in American history of coolly calculated, dehumanizing abuse and physical torment to extract information. This was a mistake, perhaps a disastrous one. It was a collective failure in which a number of officials and members of Congress and staffers of both parties played a part, endorsing a CIA program of physical coercion even after the McCain Amendment was passed and even after the Hamdan decision. Precisely because this was a collective failure, it is all the more important to comprehend it and learn from it. For several years, our government has been fighting terrorism without using these extreme methods. I can comment on that both worldwide and in Iraq. We've been doing this under international standards for years. Now, we face some serious obstacles in defeating al-Qaeda and its allies, and we could be hit again, hit hard. But our decision to respect international standards does not appear to be a hindrance in this fight. In fact, if the U.S. regains higher ground in the wider struggle of ideas, our prospects in a long conflict will be better. Others may disagree. They may believe that recent history, even since 2005, shows that America needs an elaborate program of indefinite secret detention and physical coercion in order to protect the nation. The government and the country needs to decide whether they are right. If they are right, our laws must change and our country must change. I think they are wrong.
Thank you, Mr. Zelikow.